Something massive is shaking the U.S. immigration system in May 2026, and most people have no idea it's happening until it directly affects them. Reports and internal discussions suggest a possible 39-country travel and visa restriction list that could reshape how thousands of applicants, workers, and families enter the United States. While nothing has been officially confirmed by USCIS, the details circulating behind the scenes are raising serious questions, confusion, and even panic among applicants worldwide. What countries could be affected? Why now? And more importantly, who decides who gets left out of the system? This isn't just another policy rumor. It's a situation that could impact students, job seekers, green card applicants, and even families waiting for reunification. And the most shocking part? Many people currently in the process might not even realize they are on the edge of being affected until it's too late. In this video, we break down everything currently known, what USCIS has not clearly stated, and what immigration experts are warning could happen next. Stay tuned, because the implications of this update could change your plans, your status, or even your future in the US. If you want real-time updates on immigration changes that matter, make sure to like this video right now so you don't miss what comes next. Comment below where you are watching from and whether this update could affect your immigration journey, because your experience might help others understand what is really unfolding right now across the world today together now. If you're hearing this for the first time, it might sound unbelievable, even exaggerated, but that's exactly why so many people are paying attention to it right now. Because in the world of immigration, things don't always become official before they start affecting real lives. Policies often begin as internal discussions, drafts, security reviews, and diplomatic considerations long before they ever reach a public announcement. And that is where the current concern around a possible 39-country restriction list is creating so much noise. Now let's be clear from the start. As of right now, there is no officially confirmed nationwide USCIS announcement that explicitly enforces a finalized 39-country ban. However, what is being discussed across immigration circles, legal communities, and policy watchers is that certain countries are under increased scrutiny due to evolving security evaluations, visa overstay statistics, documentation verification challenges, and broader diplomatic considerations. These discussions are not new in U.S. immigration policy, but the scale and timing being talked about in May 2026 is what has triggered widespread concern. For many applicants, especially those already in long visa queues or waiting for family reunification, even the hint of a restriction list feels like a sudden wall appearing in front of their future. Imagine waiting for years, collecting documents, paying fees, going through interviews, and then suddenly hearing that your country might be added to a list that changes everything. That emotional weight is what makes this topic so sensitive. To understand what's happening, we need to step back and look at how immigration policy shifts actually begin. USCIS does not operate in isolation. It works alongside the Department of Homeland Security, the State Department, and various intelligence and administrative bodies. When a country is evaluated, it is rarely about one single reason. Instead, it's a combination of data trends like visa compliance rates, identity verification reliability, overstays, geopolitical tensions, and security cooperation levels. Over the past few years, global migration patterns have changed dramatically. Increased movement due to conflict, economic instability, and education demand has put pressure on visa systems worldwide. The United States, being one of the most sought-after destinations, constantly adjusts its screening mechanisms to manage this flow. Sometimes these adjustments are subtle. Other times, they become highly visible policy shifts. What is making this situation feel different is the way information is spreading. Social media, immigration forums, and unofficial reports are amplifying every small update, creating a sense that something massive is about to happen. And while not everything circulating is accurate, the concern itself is real because even minor policy adjustments can have major consequences for individuals. If we break down what a country restriction list typically means in immigration terms, it does not always equal a full ban. In most real cases, it refers to increased vetting, longer processing times, additional documentation requirements, or temporary pauses on certain visa categories for specific nationalities. However, in public discussion, these distinctions often get blurred, which leads to fear and confusion. Now, the reason the number 39 is being mentioned so frequently in discussions is because of speculative reporting and early interpretations of internal review patterns. In reality, lists like these are not static. They evolve, they change, and they are rarely released in a simple public format labeled as a fixed group of countries. Instead, changes tend to appear gradually through visa bulletin updates, travel advisories, and procedural memos. For someone applying for a student visa, a work visa, or a green card, the biggest concern is uncertainty. Not knowing whether your case will be delayed, reevaluated, or moved into a different processing category creates anxiety. And that is why conversations like this spread so quickly online. But here is something important to understand. Even when restrictions or enhanced screenings are introduced, it does not mean permanent exclusion. Immigration systems are dynamic. Countries move in and out of different levels of scrutiny based on updated data. A country facing stricter checks today may not be in the same category a year later. Similarly, new diplomatic agreements can ease restrictions over time. Let's talk about how this could practically affect different groups of people, because not everyone is impacted in the same way. For students, especially those applying for F1 visas, the biggest impact is usually interview scrutiny and financial documentation checks. If a country is under higher review, applicants might be asked more detailed questions about funding sources, academic intent, and post-study plans. It does not automatically mean rejection, but it does mean a more thorough process. For workers applying for H-1B or similar employment-based visas, employers may experience additional documentation requirements or delays in processing. Companies sometimes need to provide stronger evidence of job roles, salaries, and business necessity. For family-based immigration, the emotional pressure is often highest. People waiting to reunite with spouses, parents, or children may experience longer wait times if processing priorities shift or if consular workloads increase due to policy adjustments. But one of the most misunderstood parts of immigration policy is the idea that everything changes overnight. In reality, even major policy shifts take time to implement. They go through internal reviews, legal assessments, public feedback phases in some cases, and operational adjustments across embassies and service centers. So why does it feel so sudden when these topics appear online? The answer is simple. Information travels faster than implementation. A memo, a proposal, or even a leaked discussion can reach millions within hours, while actual policy execution may take months. That gap between information and implementation is where confusion grows. Now, let's address something very important. Whenever topics like this trend, misinformation also increases. Some sources may exaggerate numbers, misinterpret official documents, or present assumptions as confirmed policy. That is why it is crucial to separate verified updates from speculation. If USCIS or the U.S. government were to implement a formal multi-country restriction policy of this scale, it would be accompanied by official notices, public statements, and detailed guidance for applicants. It would not remain hidden or unofficial for long, because immigration systems require transparency for legal processing to function properly. At the same time, it is also true that preliminary policy signals often appear before official confirmation. This is why legal experts and immigration analysts pay close attention to patterns rather than isolated headlines. What should viewers take away from all of this? First, awareness is important. Immigration systems do evolve, and staying informed helps you avoid surprises during your application process. Second, panic is not productive. Even in situations where restrictions increase, there are usually pathways, exceptions, and alternative options depending on visa type and eligibility. Third, timing matters. Many immigration changes are phased in, meaning applicants already in process are often evaluated under different standards than new applicants. Right now, The most responsible approach is to monitor official updates rather than react to speculation. Check verified USCIS announcements, embassy notices, and reputable legal analysis before making decisions based on viral claims. For those currently in the immigration process, the best strategy is preparation. Keep your documents complete, ensure your financial and identity records are clear, and stay updated on any communication from official sources. In most cases, delays or additional scrutiny can be managed with proper documentation and timely responses. At the end